bill. Who knows, or who thinks they know something about the planning amendment bill? I've been around for a long time, and the Planning and Environment Act was momentous in the world of local government, the world of planning. It actually introduced for the first time the ability for councils to collect fees, and it set up a really strong planning framework for councils to actually then have responsibility for and deal with planning permits, planning scheme amendments, and their responsibility for their own municipality from a planning point of view under a framework set by the state government. So that was the first time that actually brought that all together and gave the councils that real strength. And planning departments were actually set up for the first time. Before 1987, planning departments were often run by engineers, particularly engineers in the room. It's I'm not actually being critical of that, but the whole system was different, right? So after 1987, we had this planning industry in local government that was born, and in the mid-90s, we reformed how the planning schemes were set up with the VPPs, and essentially the format of the VPPs and the planning tools with zones and overlays, and the structure they are now was set up in the mid-90s, and that was a fundamental shift and change in the planning system. What's proposed with this bill is the biggest change in the planning system since those two scenarios. Yes, the Planning and Environment Act needs some reform. It needs to be reset, it needs to be changed. What's proposed as part of this bill is absolutely significant in terms of that resetting and what it might mean for us. It really consolidates and brings together a lot of what we've seen in the reforms over the last 2 years. It really brings those together and consolidates that approach. It takes it to a whole other level again. I'll go through a little bit about what's changed, and there's an opportunity to ask questions. I won't know the answers to some of those questions, no doubt, because I don't know the ins and outs of the bill fully myself. And we might have some change to it. As I said, it's been through the lower house of Parliament, going back about 4 or 5 weeks ago. In fact, it was the 28th of October, it was introduced to the lower house. It's been through the upper house in part, and it's been rescheduled for further debate in the upper house and consideration, as I say, literally as we speak, it should be being debated at the moment. So it'll be interesting to see whether that gets through or whether that gets referred off for an inquiry to investigate some of the aspects of the bill further, or whether it's approved with change. And what would happen if there's change, there'll be amendments put forward through the upper house, which, if accepted by the upper house, will then get sent back to the lower house. I think there's only a window of tomorrow or Thursday for that to be approved this year. If it doesn't happen in the next 2 days, then it will get referred off to next year. So we'll see what happens there. So I'll go through the different sections of what's happened with that bill. There's new objectives that are proposed, and the new objectives do tackle issues like climate change and housing. And they make housing really one of the central platforms of this change of the Act. One of the issues raised by local government, and you know, we've had input to the MAV local government position paper. That local government position paper, which I did circulate around, but if you haven't got it, I'm happy to share that with you. That local government position paper has been accepted and agreed by all councils. No one's actually taken a position, no council's taken a position contrary to that. So it's pretty comprehensive and covers the issue as well. But what's been pointed out in that paper is planning is more than housing. And housing, yes, it is important, it is the topic right at this point in time, but we've got to think broader than just housing. So the new objectives do pick up on some of the other issues like climate change, but there were also some changes that actually weaken some of the protections on environmental issues and other issues as well. So there's a bit of tweaking to the objective It also sets up that the minister can prepare and will prepare regional state policies and regional policies. So it really sets up a formal framework for documents like Plan for Victoria, but also regional plans if they suit and are appropriate, like a part of the Melbourne metropolitan area. The VPP, so the Victorian Planning Provisions, sets up for planning scheme amendments. Planning scheme amendments categorised into low, medium and high impact amendments, and then certain processes that will form or support each of those amendment impact categories. One of the problems that we've got in large part with the bill and what it's proposing is that it leans very heavily on new regulations and guidelines. So it sets up a framework and says, yes, let's have low, medium and high impact amendments, but then says, but we're going to develop new guidelines and tell us what fits into each category. So how do you make a judgment about whether that is actually a good planning system or setup? We don't know what's going to be in those guidelines yet, which amendments are fall into those different categories. Some of those amendments in the lower categories make sense. They're streamlined, they're more straightforward. They can be approved without having to go through the same notification and same planning panel processes, and they're much more straight to the point to make the decision. So we know that there should have been some reforming of the planning scheme in terms of how we deal with amendments. Whether it's fully right remains to be seen, and whether it's fully transparent in terms of the community input or involvement in that with the notification parts. There will be, for streamlined amendments, an engagement plan requirement for all amendments. So the new streamlined process, there'll be engagement plans that councils need to specify how they're going to engage with the community as part of those amendments. Also, as part of the VPPs, the minister will have new powers to direct the council to amend a planning scheme if their planning scheme is not consistent with the state and regional plans that have been developed. So you know how we've had this threat? The minister has said, councils, if you don't change your planning scheme and make sure that they meet with the housing targets and do certain things, then we're going to come in and change your planning scheme, which they can kind of do now, but it's a bit more clunky. This will consolidate that ability not only for the minister to step in, but the minister to say to the council, you must change. Legislation says the minister has the power to make a council change their planning scheme. And the other big one is that planning scheme amendments currently go through the lower house and upper house of Parliament. Now they go through and are just listed, but there is an ability for Parliament to take a position against a planning scheme amendment when it passes through. And this bill looks at removing that ability. So it gives transparency to planning scheme amendments. All planning scheme amendments that this happens with, very few get held up or get blocked or get stopped through Parliament. But it gives an oversight for both houses of Parliament to see every planning scheme amendment. The new bill would say, no, that won't happen anymore. The government can set up its own committee that it actually has majority numbers on to oversee planning scheme amendments and keep them on. So it really removes that scrutiny and that transparency. Speaking of consultancy and transparency, I mentioned that there would need to be engagement reports, but there'll also be reporting on the engagement that's happened. Explanatory statements for decisions. So decisions will need to have explanations of why they've been made in a particular way. This includes with the minister. So at the moment, often we don't always get a full explanation of why a particular decision has been made. And also performance reporting on amendments. So as a bit in the consultancy and transparency, it actually is an improvement, and it certainly picks up on some of the Operation Sandon expectations and recommendations. Planning permits, the big one for our day-to-day decisions. 3 types of planning planning permit categories. Type 1, pretty much our big smart applications, 10-day time frame. Type 2, 30-day time frame for decision. Type 3, 60-day time frame for decisions. No resetting of the clock. Yes, some stopping of the clock, but no resetting of the clock along that process. If we don't, applicants get to choose which path they're on, type 1, 2 or 3 when they lodge their application. If we don't correct them, and put them on the right path within 5 days, then they're stuck on that path. So if they're a 60-day type 3 application and they've submitted as type 1, if we don't correct it in 5 days, we're stuck in type 1, we've got to make a decision in 10 days. If we don't make a decision in 10 days, the applicant gets to make a decision. They get to notify us and tell us, right, you didn't make a decision in 10 days, I'm now going to issue myself a permit and these are conditions I'm going to use.
Wow.
Permit conditions have to come from a set of conditions that sit in guidelines, which we haven't seen yet, of course, guidelines, that the state government is going to decide. So they're going to decide the conditions, and we can only use conditions from that suite. We can't change those conditions. If a topic isn't covered by the conditions, which are meant to be comprehensive, but if it isn't, then we can have a condition ourselves. But if the topic or issue is covered by the set condition, we have to pick up that list. Notice. Type 1 applications, no notice or objections. Type 2 applications, no objections. Notice, if the guidelines say that type of application will have notification, but no third-party process. So it's a submission, not an objection. And then type 3 will be notification and objection, but notification is only to the abutting properties, and objection is only from those parties that can then take it third party. So we can't, it's not anyone. You can't be in the next street, object, and then appeal to VCAT. Only the select parties that can actually appeal to VCAT. Again, we don't know what's in type 1, 2 or 3 yet. Guidelines are going to tell us, of course. Don't know what's in the guidelines yet. It was indicated early that up to mid-rise code developments would be type 2 with no notification. And that includes no third-party rights, even if it's not deemed to comply. Now, whether that's actually how it plays out, once the rubber hits the road and there's a little bit of angst in the community, we don't know. We'll see. It might be that they do have notification or they do tip into type 3, but that's what was indicated early on. So pretty significant change to the way that the planning application process will work. Of course, the consolidation would need to comply. The gifts and donations requirement, again, this came out of Operation Standard, quite complex and quite heavy in terms of the expectations. Basically, all of us that are involved in planning applications and plan scheme amendments will have to be declaring whether we've given any gift or donation to any party that's associated with that application. Objectors will need to do the same. You can imagine objectors having to do the same. If the application is going to be decided by council, then it's a gift or donation to a party that the council represents. It can be quite complex and involved. It's going to be quite heavy in these gifts and donations. So all for transparency and openness around gifts and donations, but it's got to be workable as well. It's got to be practical, and you can imagine we're probably trying to explain to objectors that you can't object unless you declare gifts or donations you've given to parties associated with a developer or council or councillors or others. Compliance and enforcement, lots of good changes in the compliance and enforcement space. I think lots of opportunity there with increased penalties for infringements. Magistrate having powers beyond just issuing a fine. The magistrate will have powers that can put orders or requirements in place on developers or anyone that might benefit from an action or breach or thing that's occurred. So, you know, just to put in place restrictions or preventions on someone benefiting from an illegal act or an illegal planning act. So there's a fair bit in there that you know, we really want to pull apart a little bit more and understand, but there's good opportunities there in improved enforcement. And monitoring new guidelines or policy on enforcement that will be developed by the DTP. Compensation, changes to the compensation process for loss when there's an acquisition of land under planning. Infrastructure contribution system, so some changes there that supports the infrastructure contribution system. Expanded use of funds, so funds that are collected for particular use could be used for council and state infrastructure. You might have seen that in the draft infrastructure contributions framework that was put out last week. So there's an ability that the legislation will support the expanded use of those funds, and the minister can direct how the funds get used for contributions. Covenants, this is another big one. So we know about covenants, and there's two aspects of the covenants. Firstly, at the moment, as we know, we can't issue a planning permit that's in breach of the covenant. Now, we don't have any responsibility for the covenant, we don't enforce the covenant, we don't have any role in if the covenant's put on a property, but we have an obligation to ensure we don't issue a permit in breach of the covenant. It can get quite complex and legalistic, can't it? So the idea is that that will be decoupled from planning. So you will make planning decisions purely on the planning merits of what's before you under what is essentially the public planning system, the Planning Environment Act and the Planning Scheme. You'll ignore the covenant. In fact, you won't allow it to look at the covenant in making your planning decision. It'll be irrelevant. So it's a big shift, a big change that actually simplifies things a little bit in those scenarios where we do have covenants. The other change to covenants is where there is a covenant and someone is applying to vary or remove their covenant. It will be a little bit easier for covenants that are prior to 1991. So you know how it's a little bit easier for covenants post 1991 compared to pre-1991. So pre-1991, essentially if anyone objects, you can't vary or remove it. It'll actually make it much more consistent for all covenants, make it a little bit easier for those pre-91 covenants to be varied or removed. And then there'll be sort of things put in place for transition to the new system, which we expect, if the bill is passed and it becomes Act, we expect that to be put in place by October 2027. So we've got just under 2 years to transition into it. Council will need to reform and change their whole planning systems. Lucky we're getting a new one with our PPP, we can build it to the new framework. But you can imagine it's huge in terms of those changes to systems, changes to process, changes to approach and understanding of how we're going to manage the applications and manage the residents. As I say, the MAV position paper, it actually put 32 recommendations recommending some specific changes to some of the sections of the Act, really to improve some of the notification processes, transparency processes, making it a little bit fair and not giving the applicant control of an outcome if there's a little bit of an error or backlog. Imagine, you know, we get inundated with applications next week before Christmas and you don't get to them all in 5 days over the Christmas period. Okay? But they're all now stuck in the stream, right? We can't have that, in our view, as an acceptable scenario for planning applications. Yeah?
Is there any other statutory process you can think like, I can't issue my own passport, but where else does that thinking exist? Like,
Yep. Yeah, there are, and one of the other aspects we don't even mention, referrals. So referral authorities, essentially, if a referral authority does not respond in time, there'll be time frames for referral authorities, it's deemed approved, which is kind of the place now to a degree, but we don't always apply it in that way, but we're going to have to. Yeah, so yeah, I don't know. I'm not aware. Like, it's not generally how you set up legislation. You don't set it up that the general public or developers or whatever get control of their outcome. And essentially, if we don't do this well, and look, we'll be okay, right? We're Boroondara. We'll do this okay. But can you imagine a bullock that has a part-time planner that comes twice a week to do the applications, and they're away sick for a couple of days and don't come in that week?
yeah.
Like, is that an okay situation? Is that fair on a council like that? So, yeah, it's quite a bizarre way of setting up a system.
Section 29A has the same.
It does.
Demolition.
Yeah. Yep.
Protection to adjoining property protection laws.
Yep. Yep.
Don't
Yep.
respond.
Yeah. So I can understand it, but it's a little bit different in that you're not actually making a decision in time and it moves on. Where this is actually someone now gets the power to make a decision that's not that it's deemed okay. They actually have to now issue themselves a permit with conditions. You know what I mean?
Yeah.
It's a little bit. It's taking it to another level.
So all the developers will have their own stand on it, approved.
Yeah.
See?
But what's the value of a permit without endorsed plans?
What's the value of that?
Of a permit if you don't have endorsed plans, well, where you can take it, you still need your endorsed plans.
Well, I'm not
To be
issuing
able to
myself a
build.
permit requiring any endorsed plans.
Yeah.
I'm issuing a permit saying that I can deliver the development as shown on the plan submitted with the application. That's how I've structured the permit condition.
So,
Okay.
so
I don't know. I don't know the answer to your question. I understand the point, and you're right. You know, it might be it's a crazy permit, or you know, but once you've got the permit, we can't go and change the permit. And if the permit conditions are saying, you know, endorse the plans that were submitted with the application, which is essentially what they will say, you actually don't get to. You're obliged to endorse those plans. Otherwise, you'll get taken to VCAT for.
So an applicant can issue themselves a permit without like the condition 1 and condition 2.
Maybe, yes. That's how I'm assuming, that's how I'm reading it. But we don't know. Look, we don't have the guidelines of how this will all work, and we don't know how practical it is for an applicant actually to issue a permit. But the implication of it is there. Yeah.
but they still can't build it, so it has to come to a building survey. So what are we looking at?
Are we looking at?
Builder's plan, we won't issue building permit.
Yeah.
Unless the building legislation will
Yep.
change.
Yeah, and some of this we don't know because we don't have the guidelines of how it will work, but the implication is there in terms of the way they've set up the system. I mean, you might argue that you know, this is really set up as a threat. Some of these things will be pulled back, but you know, we're not seeing that. The government's not actually backing away from trying to get this through Parliament as is and as they've structured it and as they've drafted it. Other questions?
Are there any other states doing the same thing or same proposals?
Not to this extent. The Queensland system and New South Wales system, New South Wales system is a different system altogether in the first place. The Queensland system was already, you know, much closer to this sort of approach. So, yes, but we've taken it to
Next step.
another level.
Why not just take housing out of planning completely at this point where it is deemed to comply and applicants are issuing their own permits?
More for us,
Just, well, no, just, like, what's the value of that?
Yeah, well, it's a really good question, and I've talked in the past about our planning system and what it looked like, you know, in the late 80s. What did the planning system look like at that point? And it was very much a tick box planning system around housing. The housing part was very much a tick box system, and we moved in the 90s to a performance-based system because we went, it's getting crap outcomes. We're getting crap outcomes on the ground. How do we move this to a position where it's actually much more closer to the type of system where we can make a judgment about the quality of the outcome of the development? Now, it doesn't always lead to that, we know that, but it's given us a much more robust system and assessment process. This moves it back to a tick box, but won't stay there. So you will not stay there because we are going to get some crap out. We're seeing some of the applications come through. We're seeing some of those that we need to approve as deemed to comply. It will not stay there. I'm confident of that.
Jack's tracker,
Yep.
does it track the lag between permit issue to certificate of occupancy? Does that give us a timeline for when we're going to see these crap outcomes
On the ground.
on the ground?
So the tracker does do that. You can do that using the tracker, but the lag is quite significant. The lag is quite significant. It's not consistent, so you can't say there's a consistent lag, but it's many years. And that's why, you know, that's a frustration. This planning amendment bill doesn't deal with land banking of permits and developers getting permits, sitting on them. You know, one of the most frustrating things for us over the last few years has been negotiating with a developer. How many have we had in Camberwell, even Glenferrie, but most in Camberwell? Negotiate with a developer, they hop up at the UPDC, they say, I get my permit, we're going to start building in the next 3 months. And what's happened? They get their permit, for sale sign goes up.
Yeah.
And what happens when a for sale sign goes up? What have they done? All they've done in getting that permit is maximising the value of that land. They've increased the value of that land. So they've sold at a maximum price to a developer, or someone else has now purchased that. So what does that purchaser need to do now? They've now got to get a greater value again. So how do they get and make the project work? Two different ways, aren't there? What are the two ways? Strip out poly, make it a cheaper build, or add additional apartments and additional building, or maybe both. And so we're then left with a problem again. Oh, and we can't get it to stack up, so we don't build it, and we sit on it, and we'll wait for the values to increase before we build it. So yeah, this change of the planning environment has done nothing to address that issue.
Yeah, it'd be interesting to see if to even break that down by 2 and 3 dwelling developments. If there is a sweet spot of what type of development maybe gets built on the ground faster.
Yep. Good. So this we can do some analysis on that. So that'd be interesting. Because now we've got the data in there, we can start asking ourselves those questions and then pulling the data out and analysing in that way. So that's a great question that we should ask ourselves. Casey?
Do you think we're going to get an increase in applications or a rush before the infrastructure contributions?
Yeah, so interesting thing with the infrastructure contributions and the car parking change. So let's put aside the fact, firstly, for a minute. Well, no, I won't put that aside. So we've got two things that were announced last week. Is the infrastructure contribution system, and that infrastructure contribution system is going to enable or require a contribution, I think it was 11,350 per dwelling. 11,350 per dwelling, which will be 70% to council, 30% to the state government in terms of the contribution. So that's great. We'll get that at C of O when the development is complete. At certificate of occupancy or statement of compliance, we get that money. That's great. It only applies firstly from January 2027 to Camberwell, and then from June that year, 2027, to the other 6 activity centres. So the catchments and the activity centre. Doesn't apply outside of that. The second thing is a change to the parking rules. Great, I know, you're sitting there saying, fantastic, can't wait. The parking rules are going to change, so it means that in an activity centre, all of a sudden, you don't need to provide parking. It's going to cut the cost of development down, means that developers are going to be easier for them, we're going to get more developments. Problem with Boroondara is that we have a parking overlay in most of our activity centres that has a higher parking rate than the current planning scheme, and they haven't changed that. So, we've got a scenario where in Boroondara, if you want to go and build in the activity centre, which is where we want everyone to build, don't we? We want the apartments in the activity centre, next to the stations, next to the service facilities, in the right spots. It's going to cost you, not only is it going to cost you an extra $11,500 per dwelling, it's going to cost you what it costs you to build 2 car parking spaces plus a visitor space in 1 every 5 units. But imagine the cost of that. That's a couple of $100,000 per apartment, extra cost. Compared to if you go outside the activity centre, you don't have to pay those 2 things. You can provide less car parking, avoid providing the car parking, and you don't pay the infrastructure levy. So you can see some of the difficulties in the planning system that has that really been thought through, and are we setting that in the right way to get the outcome that we're saying that we want? So it's quite a dilemma. We don't want our residential streets to be the target of the developers. Yeah, it can accommodate some incremental infill, it should, but we want it to be focused on the activity centre. I'm not sure that those 2 changes announced last week help us do that.
Well, it's more frustrating because the government's done this before and seen that it doesn't work. And Dandenong, the infrastructure recovery charge was put on a certain area when the government came in and bought up a whole lot of land and wanted to get their money back. And all the development happened outside the ring until they took it off, and then finally development would go ahead again because of this.
Yeah. I don't know why you wouldn't actually weight it the other way. Because it costs more to deliver the services outside of the activity centre, in fact. So why wouldn't you weight it that way? But, yeah, sorry, yeah.
The market here in Boroondara though seems to require car parking. And we're seeing applications with more than what the scheme requires for some of these. I'm buying a luxury apartment, I want a car space, I still have a car.
And I think for the category 1,
Yeah.
in
Yeah, there's 4
Camberwell was,
spaces.
and the irony is, at the information session last week, Camberwell was given us an example of where and how you use the new system for car parking. And I said to Jim Papadimitriou, the president, I said, why would you use Camberwell as the example when we've got a parking overlay? Because it's not the example, it doesn't make any sense, it doesn't work. But it was given us the example, and that would be category 1. Which means you wouldn't be able to provide, there's a cap on the amount of parking. You can't provide as much parking as you like, I don't think, in that scenario. But I haven't seen the detail yet, the final rules. That's going to get, that'll probably be a Christmas present for you, I suspect.
But developers, I think they'll go to market and go, or they'll do it, people want car parking spaces.
No, I understand that.
Well, some people do. And this is the thing, developers are often not very sophisticated. They go, what did the last development sell for? Did it have car parking? I've got to provide car parking. If you look at it at a global level though, they did this in the UK, where you had car parking, you had no minimums in, you had maximums, no minimums in London, but nowhere else. And they took it off the rest of the country, and the number of car parks that developers built went down by 50%. So the market will take a while to adjust, but I don't think that.
Do we have the public transport and walkability here in Melbourne to support people not
Not really.
having cars?
Well, yes, in a lot of these areas, yes.
Yes, in a lot of them, but in a lot we don't. But the idea is, the whole planning system is now being set up to actually make that shift. So if you make it cheaper and easier to build with no car parking in the places where the best public transport is, there's going to be market conditions that drive some of that change as well. So I actually think it's the right way to go, but you've still got to then keep providing the public transport infrastructure to support it.
And
You've got to beef that up and pump that up.
The data on the number of young people who are getting driver's licenses now has gone right down. So it's often for a lot of people cheaper to Uber everywhere than own a car. So it'll be a slight change, but I reckon it will over time make a big difference.
What we're going to have to do, well, the other thing, we're going to talk to the department about, because I said to Jim a couple of years ago, I said, why don't you just remove our overlay? Like, why would you introduce this change and leave the overlay in place that has a higher rate than even the existing planning scheme? It's crazy. So, I'm sure you had a convincing answer to that, but we'll go and talk to them and see if we can get that overlay removed, because it's not the outcome that we want. And it's not the outcome that our councillors want either. They want the new rate. They want the new regime. They actually want to put more restrictions on car parking in the surrounding streets. We actually need to complement the two. It's not just changing the rules for development, it's actually what you do in terms of supporting active transport, cycling, pedestrian activity and use, and restrictions on car parking in the surrounding streets. We don't want to continue with giving 4 permits to every house in the permit areas.
Yeah.
Let's pull that back, lock that down, put in tighter restrictions. Because we need to do that to complement and support what we're doing on the private land. Otherwise, it doesn't work. People just park around the streets. Any other questions on reform overall? Any of the reforms, Riley?
Just a quick question. Do you know why those parking methods put there in the first place?
Well, that was really Boroondara Council's way of counteracting the change that reduced, because the car parking rates were revised, what was that, about 10 years ago, 15 years ago? They pulled them back a little bit, reduced them down, and Boroondara, as I understand it, Boroondara went, well, we're not happy with that for our activity centres. We want to keep the rate higher, so they introduced a parking overlay. Is my understanding. Does anyone want to correct me or confirm that's the case? The error, or it's John?
Correct.
Different council, different point in time. The current council wouldn't do it. The problem that the current council's got is, or that we've got, is if we don't get a magic wand to change that overlay by the minister, we're going to run a whole process. And we're going to go out to the community and run a planning scheme amendment and consult and ask, what do you think if we remove the parking overlay? What do you think is going to happen? We're going to have the chamber full of people saying, no, don't take the parking overlay away, keep the parking requirements the way they are. We don't want new development to come and have no car parking. They're thinking about themselves and protecting themselves. They're not thinking about the future of our municipality. So it's not a great position for the government to put us in, even if we want to change the overlay, and the council will actually try and have a crack at going through that process, I believe. But gee, what a waste of effort it's going to be for us all. And what a waste of time, and what a waste of angst that we're going to create in the community for that.
So if the state government does, it'll be a lot quicker and easier to get it.
Well, they've waved their magic wand to change the parking rates. Did they consult with anyone?
Yep.
So if they didn't consult with anyone on making this change, which is fundamental, you sort of go, well, why are we going to get made to go through a process? but we will. That's the crazy part. So we'll see what we can achieve there. Other questions? Other reforms? We've had so many, haven't we?
Yeah.
All right, pop quiz. What's your favourite reform so far? Come on, John. What's your favourite
Like,
reform?
if the bill gets up, it'll be not assessing covenants.
Yeah.
That drives me nuts.
Yeah.
Because you speak to any lawyer and they can mount an argument on either side sometimes whether or not a planning application will breach a covenant.
Yep. Yeah, and it's crazy. And in fact, I might have told this story before, this linking of covenants with the Planning and Environment Act only happened in 2001. And that happened as a result of a planning application that I was involved in at Daniel. And the application was in East Ivanhoe, and it was actually at the East Ivanhoe shops on the location there where there's a roundabout at the top, and some of you that might have driven past there might have seen a development there. I think it's even still there. But what had happened was a particular developer applied for a 3-unit development on a site where there was a single dwelling covenant. And council, for a whole bunch of reasons, not because of the covenant, but a whole bunch of reasons, refused the application. Went off to VCAT, got a permit. Started building the units and applied for subdivision into 3 lots, subdivided and sold off the lots. Halfway built, residents in the area were livid. You know, they'd been demanding the council, they went to VCAT, they did everything. So they got together and they went and got an injunction at the Supreme Court to enforce the covenant. Cost them $1 million. They were successful in getting that injunction. So development stopped and was left there for the next 20 years, half built. But that community group then went and petitioned the Minister for Planning and said, this is ridiculous that your planning system makes residents have to run off to the Supreme Court and get an injunction to stop a development that's contrary to a covenant. What are you doing? And guess what? It was 6 months out from the election. What do you think happened?
Yep.
Magic change to the Planning and Environment Act. And that change connected the two things together. Covenants are private planning, effectively. Now, they've been around for hundreds of years. You've seen some of them at Boroondara from 100 years ago that say all sorts of crazy things. They, I had one. I remember quite clearly. There was a covenant related to the maintenance of a horse trough in the front of the house. This is when I worked at Richmond Council. Like they say silly things sometimes, and they weren't designed for future thinking. So you've got a scenario that brought those two things together, the Planning and Environment Act and the covenants, that were never meant to be together. And that's where we ended up being in positions where we're interpreting covenants and interpreting materials and finishes of, you know, not even thinking about that there will be modern materials coming in the future, aren't we? We're interpreting those and trying to reset those and based on covenants, often that were written by, they weren't all written by smart lawyers back then either. They weren't all written by lawyers. So the covenants sometimes are very poorly written too. So understanding what they're actually on about and what they're trying to achieve is quite difficult sometimes. But yeah, I agree. Up until 2001, we didn't have that restriction. In fact, you couldn't turn your mind to a covenant. So when everyone would come in and object, we'd say, we're not looking at the covenant. We're looking at the public planning system and the planning policies. Is this a good outcome from the planning policy point of view? Which is exactly what we should be doing as planners. We shouldn't be looking at private contracts, effectively, what a covenant is.
I was actually disappointed with the covenant changes, that we're still doing bury and remove covenants.
Yep.
Like, I would have loved, there's another avenue for
Yep.
covenant variation and removal.
Yep.
I would have been happy to
Yep.
get rid of them completely.
Yeah, I get that. I do get that. I do understand that. And this is where I do make a little bit of a distinction, however. The process to vary and remove a covenant through the Supreme Court is a is an arduous process, right? It costs a lot of money, not easily accessible. The planning system is much more accessible, and it is usually when you're varying or removing a covenant, it's so that you're not prevented from doing something that you would normally be allowed to do under the planning system. So you really usually there is a link to trying to get planning outcomes that meet the planning objectives. So I can see that there's a little bit of it's giving an opportunity or a path to getting a variation or removal of covenant easier than going to the Supreme Court. So
But if we no longer really have to turn our mind to it in the planning application, then why would you bother even varying or removing it?
yes, but remember that the enforceability of a covenant is still there. And you wouldn't, if that's a good planning outcome by varying or removing that covenant, isn't that a good thing that we're then facilitating the variation or removal of that so that we don't have people going off and enforcing a covenant and preventing that outcome from being achieved? That's how you could look at it. But you're right, maybe there is a different path that shouldn't be under the planning system, but really it's not, they shouldn't be there really, so I can see why you're saying
Simplify
that.
the process through the Supreme Court to vary or remove the covenant and take
Maybe.
it out of our hands
Yeah.
entirely.
So Scott, there is a risk for building surveyors here because it's small second building, if there's covenant. Building regulation don't recognize covenant.
No.
We can issue permits.
That's
and
right,
they can build.
there's no risk, you've got no risk.
So,
Sorry everyone, we have gone way past, so.
With covenants, it is.
Yeah, so if you need to go, but I just thought there was an opportunity while we're here.
With covenants, it is going to be a shandy approach where we have some involvement, but not all involvement. You know, we're going to hold pilot again. It's going to fall to the beneficiaries to enforce it. There will be times where council would enforce a breach of the covenant.
Council will never enforce a breach of the covenant. Go through the scenario again.
Sorry. No.
So council has no responsibility for covenants, we will never enforce the covenant. So if today there's a planning permit needed for 2 dwellings on a block and there is a single dwelling covenant, we cannot issue a permit for those 2 dwellings. If tomorrow there are planning reforms that change the planning scheme and say, 2 dwellings no longer needs a permit, it now just needs a building permit, there's no planning permit needed for the 2 dwellings, then the fact that there's a covenant there has no bearing on us now. Now has no bearing on us, and the question that Asanka has raised is said, well, there's nothing in the building legislation that means that I've got a building surveyor's bound by the covenant. We can issue a building permit, right? So if that now apply to Asanka or apply to a private building surveyor for the 2 dwellings, nothing in the planning scheme that says it, and the building surveyor will issue a permit. The covenant's irrelevant to them. So that 2 dwelling development can now happen just by a change to the planning scheme. So in some ways you sort of go, well hang on, that doesn't make any sense. Why is there restriction on planning from issuing the planning permit, but it's not doing nothing about stopping the development if the planning scheme changes? Council doesn't have any enforcement responsibility for the covenant, doesn't have any ownership of the covenant. It's just a loose connection that puts a block on certain planning decisions.
there's some civil liability there for building surveyors. There was a test case, the building survey issued a front fence where there was a covenant, and then the neighbors objected. The owner had to sort of reduce, and the owner sued the designer and the building surveyor. And the magistrate formed the opinion that as a professional you should have had a due diligence and informed the owner, professional, that there are liabilities with this, which he made.
Yeah, I mean, I would say to a developer, or an applicant, are you aware of the covenant? So just bear that in mind.
So we issued as a
The lost lots of people, so probably time to pack up. Unless there's any last burning questions. Done. Thanks everyone. See ya.